in the 454 Judicial District Court of Medina County, Texas. Court is streaming via YouTube and Zoom outside of Medina County. Are there any objections?
Okay. No objection.
All right, then Ms. Thompson, would you please begin the announcements?
Jessica Thompson for the department.
Jerome Ramirez, Permanency Supervisor.
Bernice Hernandez, Permanency Specialist.
Jennifer Harris, Attorney ad litem for the child.
Jill Roden, Tri-County CASA.
Serenity, could you unmute and announce for me, please?
Serenity.
Thank you. All right, I've had the opportunity to talk to Serenity. We're set for a progress hearing today that Ms. Harris requested, mainly so Serenity could have the opportunity to speak with me and then take up some of the issues that I believe, from what I understand, have somewhat resolved. But I am going to give the opportunity to the parties to ask questions if they want, and to go forward from there. So I don't really have any specific questions. I can relate to the parties that, based on my discussion with Serenity, she's where she needs to be right now, and she's getting what she needs. I am going to make one order that I've talked to her about, but Ms. Thompson, do you have any questions for Ms. Hernandez first?
Only one question, Your Honor. Just Serenity's performance at the DAP program, but that's really it.
Yeah, so her performance has actually been really well. Last week, I received an email from the principal that she is a completely different person from when she started at the actual high school. She's very respectful with everyone there, and she's doing her work. She showed me her grades last Thursday when I went to go see her, and she's very focused to getting all her grades up, knowing that she just started her classes.
Okay.
Any other questions, Ms. Thompson?
No further questions, Your Honor.
Okay. Ms. Harris?
So will she be able to receive credit for the semester since she's missed a lot of classes and the move to her grandparents, the move to the alternative program?
I will have to ask the school about that. I know that she is doing basically like a credit recovery, so she is working at her own pace right now. Therefore, she possibly could receive the full credit if she continues to do all her work as she's been doing.
And will she continue in that credit recovery program when she returns to the main campus?
That's something that I would have to talk to the school about.
And there was a delay in getting the alternative campus started, correct?
Yes, there was.
Can you explain what the problem was?
Yes, the problem was transportation in the morning to get Serenity into school.
And why is placement not able to get her there?
Her grandmother takes care of her other grandchildren, so she has a hard time getting Serenity to school.
Is she having to take the other grandchildren to school?
She watches some of her grandchildren. She babysits.
So is she just not able to get all the kids loaded into the car, or what's exactly the issue?
That, and she also recently had surgery last week, or 2 Fridays ago.
Is somebody available to get Serenity around to other appointments that she needs to get to?
Her grandmother makes herself available on the days that she can. I believe she doesn't babysit on Fridays, so she tends to schedule Serenity's appointments on Fridays.
And what about therapy? What is happening there?
She's doing virtual therapy with her same therapist. She had told me that she enjoyed working with her. I mean, she didn't have many sessions with her, but she's still working virtually with her. Today, she actually has a session this afternoon.
And how often are those sessions going to be?
They're supposed to be every other week. Last month, she only had one, but missed that one.
Considering the recent issues, do you think that weekly therapy might be appropriate?
Yes, I think it could be.
And the current placement is the paternal grandparents, correct?
Yes.
And why were they not placement previously?
They were not placement previously because Serenity's father was actually living in the home with them as well.
And were there concerns about their protective capacity?
Yes.
And have those concerns been addressed?
Yes. Her father is not living there. He is an inpatient right now.
And are there any plans for him to return to the home?
When I spoke to Miss Arizola on Thursday, she told me that her son is still living at the inpatient and will receive a home or will be doing some type of residency program with the inpatient program. So he will not return to the home.
Just for the foreseeable future or ever? What's the plan?
That is what she had told me as of Thursday, that, you know, that was a plan, that she plans to keep Serenity and she plans to be protective over her.
And so is Belong looking for alternative placement for Serenity at this time?
Not at this time, but we would request a staffing between all parties just to discuss her permanency plan.
And what is the permanency plan at this point?
It was relative conservatorship, but she did mention that because her paternal grandparents are her family, she wouldn't mind being adopted by them. So she would potentially want to be adopted by them.
Are there any other orders that you're needing at this point to be able to meet Serenity's needs?
Not at this time.
I'll pass the witness, Judge.
Anything else, Ms. Thompson?
No, Your Honor.
Any witnesses, Ms. Harris?
No, Judge.
Anything else you want to report?
No. The school ding was a little frustrating. I understand the situation that her family's in, but if she's going to be there, they've got to make sure she's getting to school. Belong has been able to make arrangements with transport to be able to get her there. So I hope between the two of them they can make this work, because Serenity has to finish this alternative program before she can go back to the main campus, before she can do any other online school, before she can do anything. She has to finish this program. So it's important that she gets there for it. I'm also concerned about credits and getting that credit recovery. So I'm glad she's taking it seriously and going to work hard for that. She's happy where she's at. So I would just ask for orders that that placement not change absent an emergency or further order of the court.
I might have missed it. I was reading Ms. Roden's report a minute ago when you were questioning Ms. Hernandez. I didn't hear this question, so if I missed it, I'm sorry. Is there not a bus available for that alternative campus?
No, Judge, there isn't. Alternative school doesn't provide transportation for the kids.
And that education specialist has been involved, Your Honor. We have gone round and round and round. Myself, the caseworker, Ms. Roden, the education specialist, I think has had 2 different meetings with the school to try and make this work. I think it's absolutely ridiculous that the school can require her to go to another campus and say, tough luck, we don't care how you get there.
I do too. I don't like it. Okay, is there anything else that I could order or any other ideas that we have regarding this transportation issue?
The only other idea I had was trying to get her maybe an ARD because of the anger management issues, possibly being qualified as an emotional disturbance, that might qualify her for accommodations, which I think then the school might be required to provide transportation, but of course that's a really long process, so it's not going to help during this anyway.
Do you think that we need to, she needs to have an art anyways?
I think that it would not hurt so that we can have some accommodations to for her in school when she needs to walk away from some of these tough situations.
Okay. Ms. Roden?
I'm in agreement. I think that might be helpful to start the art process, not for this particular instance. I think we'll be out of it before we get through the art process. But like Ms. Harris said, in the future, and when Serenity kind of faces those challenges like she did that day in school, it might be helpful. One of the other things that isn't mentioned is that, and we didn't get to earlier, she is back on her medication. Her grandmother took her for that appointment, and my understanding is she's back on her Abilify and Clonidine, so hopefully that's helping. Serenity had been able to kind of identify herself that coming off those medications or not taking them regularly may have made it a little bit harder for her to handle her emotions and some of the big changes. I think she's safe where she's at right now. We were one of the ones that were concerned with that placement in the beginning, but as you've heard, Mr. Arizola is not in the home. And so we're happy with her placement. We're happy that Serenity's happy and kind of getting stable there. Hopefully she's now on the right path to recovering from some of those mistakes that she made and is going to be able to comply with the AEP process and her juvenile probation.
Okay, thank you.
Mhm.
Ms. Hernandez, is there anything else that you weren't asked about that you can add?
No, Judge, not at this time.
Okay. All right then. This is a progress hearing, so I'm just going to make a few orders and a few findings. We're going to be back for our permanency review in February. That's not till February 11th at 11:30. February 11th, 2025 at 11:30. But for now, I'm going to order the parties to staff the perm plan and placement just as soon as you all can get together. It doesn't have to be tomorrow, but it needs to be relatively soon when you all have the availability. I would say probably in November. Let's do it by December 1st. I'm going to order that Serenity have an anger management component. If the therapist can provide something that works with her on how to handle anger and diffuse situations, tools and tricks to deal with that, that is sufficient for the court. If the therapist expresses reservations or Ms. Hernandez feels like she can't do that, then she needs to have a separate anger management component. She's already on probation. She's already going to therapy. I'm going to order weekly therapy because I think it's important right now. So I would really hope that we don't have to have another separate meeting. I would hope that we could do it all together. But if we can't, that anger management can be virtual so that we're cutting down on the transportation for placement. Serenity has made it very clear to me that she understands how she got in the situation. And I'm very proud of her, and I feel as if she really has taken accountability for it and understands that this was her mistake. I'm glad to hear that the school is reporting the same thing. So I think that these orders are sufficient to address what's happening, considering everything that she's got with probation. So I don't want to do anything else that's going to make it any more onerous. I'm going to find that her placement with the grandparents at this time is safe and appropriate, meeting her needs. Court also finds that at this time, Mr. Arizola is not living in the home. And I'm going to order that she have an ARD. and order that there's no moving her without either an agreement, an emergency, or order of the court. And those are the findings for progress hearing and the orders for the progress hearing. Is there anything I've failed to address?
Not from me, Judge. Serenity, is there anything we didn't get to?
No, ma'am.
Okay. Well, Serenity, it was good to see you. I enjoyed talking to you this morning. Thank you all for your time and your service. See you back February 11th at 11:30. If nothing further, all parties are excused.
Bye, Judge.
Thank you,
District Court of Bandera County, Texas. Court is broadcasting by Zoom and YouTube outside of Bandera County. Are there any objections?
No objection.
No objection, Judge.
All right. Then with that, Ms. Kyler Green, would you please begin the announcements?
Yes, good morning. Emily Kyler Green, attorney for the department.
Kira Lawrence, permanency specialist with Belong.
Rochelle Acevedo for Mr. Wynn. He's not on, Judge, but I'm ready.
Charles Weatherby for Mr. Hopkins. He's present. I'll ask him to announce his name.
Dalton Hopkins, father of Levi.
Jennifer Harris, attorney ad litem for the children.
Sarah Woods, Hill Country Casa, case supervisor, filling in for Marcus McLemore.
Ms. Kyler Green, welcome back. Ms. Acevedo, this is your motion, correct?
Yes, Your Honor.
All right. Have you conferred with the other parties about it?
Judge, I have not.
Okay. Everybody had noticed and been able to review Ms. Acevedo's motion?
Yes, Your Honor.
Yes, Your Honor. I believe notice was fine. I know that the department is in opposition of this motion.
Okay.
And the same for me, Your Honor. I also, I received notice, however, I am in opposition. I appreciate Ms. Acevedo's position. Nobody wants to represent a client that doesn't want them. But I think that this is a purely a delay tactic. We're set for trial. So I'm opposed as well.
Okay, go ahead and urge your motion, Ms. Acevedo.
Judge, I mean, essentially, I don't necessarily have a choice. My client has come to me and essentially said that I'm fired. He does not want me to represent him any longer. He has urged me to file this motion to withdraw. He wants a new attorney. I think in those communications that has dissolved any sort of ability to communicate with him for any type of preparation for trial or otherwise, Judge. I don't think that there's any way to reconcile that attorney-client relationship.
This is set for the 13th, correct? Bench trial. Okay. Miss Greenlee has informed me that Miss Fuller is not in opposition. She didn't get coverage for this hearing, but she is not in opposition. When was the last time you spoke to your client, Ms. Acevedo?
Judge, I spoke with him last week when I gave him the notice for this. I sent it via email and text. And that was the last communication I had.
Does he understand that I'm not going to reset the hearing if I substitute you?
I let him know that, Judge. I let him know that we were nearing trial, that it would be really difficult for someone to step in. And he continued to urge me to file this.
And do you know why he's not here today?
Judge, I don't know. I fully expected him to be here. He was very adamant about me filing this and about me getting off. I don't know why he wouldn't be here.
All right. I'm assuming you don't have any witnesses to call.
I don't, Judge.
Any other argument you want to make?
No, Judge. I mean, I think I've said it all. I understand that there's a short timeline. I just don't know how I can properly represent someone that obviously doesn't want me to represent him, especially at a contested trial.
Well, I can tell you from experience that it can be done. It's not fun, but it's possible. Miss Kyler Green, what's the department's position and argument? I mean, I know what your position is, but your reasons for it.
Well, Your Honor, it's not just that the trial is set for the 13th, but also this case has not yet been mediated. And it's my understanding that the court filed an order for mediation. The dates have not been set yet. There's a couple that are going around, and I intend to get that set as soon as possible. But we have the holidays coming up, and the dismissal date is in January. And I think the concern that we have is that there's no attorney who's going to be able to get their schedules situated in time to mediate, in time to prepare for trial before the dismissal date. And this case has already been reset once.
Do y'all have a mediation date in mind, or has it not even been discussed?
It has been discussed, and I think there's about four that have been narrowed down. I intend to reach out to I think it was ordered by the court that it not be an attorney mediator. And so I think we have to go through the dispute resolution center, if that's correct. So I intend to reach out to them today with those dates. But if I don't have an attorney, then I think we're going to get another delay in terms of the mediation.
Okay, maybe I'm confused. You said the order was that it not be an attorney mediator? Or did I hear it wrong?
No, I think I misspoke. Not that it is not an attorney mediator, but if the order does not have that it's an attorney who mediates, then we're obligated to go through the dispute resolution center.
I understand. Okay. Thank you. Ms. Harris?
Your Honor, I don't think this is about a case where agreeing with his attorney would make any difference for this father. This is a father who has been in and out of jail, continued to fail drug tests, failed to complete any of his service plan. So, it's not a matter of he might possibly have a chance at winning his case if him and his attorney saw eye to eye more. This is just him not liking, I'm assuming, hearing what he's facing and finding another way to try and delay this case. And that's not fair to his child. We've got a deadline and he may not be happy with it, but we need to proceed, and we can't proceed if he's not represented by somebody that's familiar with his case. I don't think it's fair for him to hold this court and his child hostage because he cannot follow orders of the court. And so just pure best interest of the child, I think that we need to continue on the same schedule with the same parties involved.
Mr. Webb, do you have anything else to say about it? Mr. Weatherby, you're muted.
Sorry, it's a difficult situation, but I don't know. I don't have any wisdom that tells me what anybody should do. I certainly understand Ms. Acevedo's position. I had heard somewhere that if you didn't want your court-appointed attorney then you had to hire one, but I don't know that that's a factor in this case.
Thank you, Mr. Weatherby. Anything that you want to add, Ms. Woods? I know you're not going to make a legal argument. I just want to know CASA's position on.
We're in agreement with Ms. Harris at this time.
Okay. Ms. Acevedo, rebuttal.
Judge, I would like to put on the record that my client has used the terms malpractice. I think it's beyond any type of fix. I think it's inviting a grievance. He does not want me on. So as long as that's on the record, because I would anticipate that he would be extremely upset if I'm still on.
I understand that. I think what is unfortunate here is that your client is telling you he wants this, but can't make the time to show up to court and make that argument himself, or at least tell me how he feels. With his track record, I'm not convinced that any other attorney is going to have any easier time. I think it's probably going to wind up the same situation. But I mean, I understand the situation of having a client who does not want you to represent them. So I'm going to tell you this, and you can tell your client. I'm not going to reset the trial. I'm going to substitute Mr. Saldivar for Ms. Acevedo, because I think that he can get up to speed in time. I'm ordering the parties to mediate prior to the trial date, and we will go to trial on December 13th. I agree with Ms. Harris. I'm not going to let Mr. Wynn, who has really not done a whole lot other than make his case worse, from what I've heard, delay these proceedings and delay permanency because he doesn't want his attorney. But at the same time, it's very, very difficult to represent a client who does not want you to represent them. It's one thing when the lawyer wants to get off the case and the client doesn't really want their lawyer to go. It's a much different situation when the client absolutely does not want to be represented by a certain attorney. I'm going to substitute Mr. Saldivar, and if Mr. Wynn decides that he doesn't want Mr. Saldivar to be his attorney either, then he's going to go to trial. He's going to be his own counsel. So you can tell him that, Ms. Acevedo, because the court's not going to appoint a third attorney, or he can hire an attorney. So the order of the court is the motion to withdraw is granted. Sua sponte, the court substitutes Richard Saldivar. And if we can make sure he gets notice of this today, I have no doubt that Mr. Saldivar will be able to coordinate a mediation date prior to December 13th. And I have no doubt that with his experience, he will be able to be prepared as much as he can be if Mr. Wynn cooperates or doesn't cooperate. Any questions?
Yes, Judge. May we have authority to switch to an attorney mediator? I think that may be critical in this case.
I'm going to order that an attorney mediator do it. Anything else that I missed? Ms. Acevedo, I'm going to order you, or the court orders you, to provide Mr. Wynn with all documents related to his file, either by and through Mr. Saldivar or directly to Mr. Nguyen, whichever is more appropriate. And then to notify him today of any of these deadlines and settings. I want the parties to set their mediation date by tomorrow at 5 o'clock. That should give Mr. Saldivar plenty of time to know when he's available. And then Ms. Acevedo inform Mr. Nguyen of the deadlines that I've imposed in this case. The deadline of selecting a mediation date by tomorrow, the trial date, and that he is ordered to appear at mediation, as are all parties. And let him know that failure to be at mediation could result in a contempt of court finding. Anything else? Okay.
No, you're not.
All right. Thank you all for your time and your service. If nothing further, all parties are excused. Screenly, I will stay on as you have requested. Just give me a minute. All right. Do we need to have any other discussions? Do we have an agreement, or are we moving forward with the hearing?
Judge, my client's in agreement. I don't know if he's logged on yet. He was having issues, but he gave me permission to move forward.
Okay. There's somebody here under a phone or device that says Adelina. Does anybody know who that is?
That's the aunt, the kid's aunt.
Okay.
It's the current placement, Judge.
Thank you. All right. So then, Ms. Acevedo, where are you and Ms. Guerra as far as the agreement? You're muted.
I'm sorry, Judge. She's in agreement, Your Honor.
Okay. And then your client's going to enter an appearance, Mr. Saldivar?
Yes, yes, Judge. He's in agreement to TMC to the department.
Okay. Well, then by virtue of his agreement, if he's going to do that, I'm going to find that he entered an appearance. And we don't have service on Mr. Volz, Ms. Thompson, that you're aware of?
That is correct, Your Honor.
Okay. So then, Ms. Pearsall, you're just going to abstain?
Yes, I announced not ready.
Okay. Then I'll get that on the record here, and we'll have to take up his issues at the status hearing. Okay, court calls cause number et al. In the 454th Judicial District Court of Medina County, Texas. Court is streaming via Zoom and YouTube from Gillespie County, Texas. Are there any objections?
No, Your Honor.
No, Your Honor.
No.
Okay. With that, then, Ms. Thompson, would you please begin the announcements?
Jessica Thompson for the department.
Matthew Schaefer, secondary courtesy worker.
Richard Saldivar, attorney for the father, Albert Flores Jr. Judge, he's trying to log on, but I do have permission to proceed.
Thank you.
Alana Pearsall, attorney for Mr. Gage, who hasn't been served, and I'm not ready.
Rochelle Acevedo for Miss Alexis Guerra. She's present. Miss Guerra, can you please announce?
Yes, I'm here.
I need you to state your name, please, Ms. Guerra.
I, Alexis Guerra. I'm here in the Zoom court.
Thank you, ma'am.
You're welcome.
Jennifer Harris, attorney ad litem for the children. I'm ready.
All right. Anybody else that needs to announce? Ms. Thompson, is Ms. Castaneda going to be your investigator, or is it Mr. Schaefer?
Ms. Castaneda.
Okay. Ms. Castaneda, did you announce?
Castaneda, the primary worker for Family Base, ready here.
Thank you.
Yes, Your Honor.
All right. Thank you. All right. We are here for this adversary hearing. My understanding is the parties have an agreement. Ms. Pearsall has announced not ready. Court takes notice that her client has not been served, and the court will grant her not ready. And we will take up Mr. Volz's issues as to the adversary hearing on the status hearing date of December 17th, 2024 at 10:30 a.m. December 17th, 2024 at 10:30 a.m. Mr. Flores has not been served. However, Mr. Saldivar has announced that he is ready to proceed and has authority. So the court will find that Mr. Flores has entered an appearance in this case and that the department and Belong are under no further obligation to serve him. Ms. Thompson, would you please state the terms and conditions of the agreement?
Your Honor, the agreement is to designate the department as the temporary managing conservator. The parents will engage and participate in services recommended by the department.
All right, and is it inherent, implied in that agreement that you'll have a family group conference
Correct, Your Honor.
and develop family plans of service?
Correct.
Okay. Ms. Castaneda, do you believe that it's in the best interest of the child or the children for the department and Belong to be named as temporary managing conservator of these children?
Yes, Judge.
And do you believe that there was a danger to the children and that danger in the home prevented the children from being able to stay in the home?
Yes, Judge.
And do you believe that abuse or neglect had occurred in the home and that attempts to alleviate the abuse or neglect were not successful?
Yes, Judge.
And do you believe that reasonable efforts were made to avoid a removal and to return the children home, but that it was not possible to do either?
Yes, Judge.
Is everything that's in your affidavit that you swore to still true and correct today?
Yes, Judge.
Okay. And as of today, you believe it's not safe to return the children home or to the parents?
Yes, Judge.
Okay. Do the parties stipulate to the reasonable efforts that were in the affidavit filed by the department?
Yes, Your Honor.
Yes, Judge.
Mr. or Ms. Acevedo, this is your understanding of the agreement? I think you might have been muted. I didn't hear you.
Sorry, Judge. It is, Your Honor.
Okay. Mr. Saldivar,
Yes, Your Honor.
Ms. Harris.
Yes, Judge.
All right. Ms. Guerra, I need you to tell me, is this the agreement that you were able to discuss with your attorney?
Yes, Judge.
All right. I'm sorry if you're upset. I understand this is difficult. I just need you to answer a few questions. Do you understand what's expected of you out of this agreement?
Yes, but can you go over it one more time?
Yes, I can go over it one more time. I just want to make sure that you did talk to your attorney about it and that you have agreed to it.
Yeah, besides the part, and when she was kind of raising her voice at me because there was a police report made because, my ex,
Well, hang on. Let me stop you. I don't want you to go into conversations that you had with your attorney.
So it was a disagreement to agree.
Ms. Guerra, I'm trying to protect you right now. You've had conversations with your attorney that are privileged. Nobody ever has to know.
With her.
Okay. I just need to know, do you want me to approve this agreement?
Yes.
Okay. And are you entering into this agreement voluntarily?
Yes.
All right. Did anybody force you to agree to this? Was that a no?
No.
Okay. And did anybody make any promises to you to get you to agree to it? Is it a no?
I don't know.
Okay. So did anybody say, hey, if you agree to this, then we'll give you this or we'll give you that? Did anybody say that?
I was just given two options to do the services, or I don't know which one. I don't remember which one was the other one.
Okay. Well, You asked me to go over it with you one more time, so I'm going to go over it with you. I'm not going to give you any legal advice. I'm just going to tell you what the agreement before the court is. The agreement before the court is that the children are going to be placed into the temporary managing conservatorship of the department and belong, which is the single source continuing contractor that's going to be working with you to provide you with the services and the help that you need so that you can address the concerns that created this case and work towards bringing your children back home. Okay, that's the basic framework of this agreement. As part of this agreement, you're going to have a meeting and y'all are going to go over the things that are concerns, go over the things that are strengths, and then you're going to create a service plan. And then that service plan is going to come before the court, and the court's going to decide whether to make it an order of the court. And then you're going to have a year to do all this. It might not take a year. You might be able to get it done faster, but you'll have a minimum of a year to work on these things before it goes to trial. The year started on November the 14th. The dismissal date is going to be November 17th of 2025. So that's the agreement that you've entered into at this time. I would defer child support and medical support at this time, so I'm not going to ask you to pay any of that at this time. And I'm also going to maintain your indigency finding if you're not currently working. Are you working right now?
No, sir.
Do you have any money to pay for an attorney?
No, sir.
Okay, then I'm going to maintain your attorney on this case, Ms. Acevedo, and she's going to continue to work through this case with you and guide you through what needs to happen next. These attorneys have been working on these cases for a long time and they have a lot of experience with these things. So sometimes the conversations you have with your attorney may not be the most pleasant conversation. But the reason it's not that pleasant is because this is a difficult subject. And a lot of times parents don't understand exactly what they're up against, and the attorneys do. So you're just going to have to trust that your attorney is trying to guide you in the right direction. I don't know what advice your attorney gave you. I don't know what was said in that conversation. I don't want to know. I just know that this is sometimes difficult, and sometimes it seems like people are picking on you. But the reality of it is that they're just trying to help you do the best thing for you legally. Okay. I just had somebody come in on a 210 number ending in 802. Can you please hit *6 and identify yourself?
Should be Dad, Judge. My client.
Let's make sure.
There's no point. There's a reason why. Oh.
All right, I'm going to mute you, Ms. Guerra, so that whatever you're saying doesn't get put on the record. Mr. Flores, is that you on the phone?
Yes, sir.
All right, sir. Could you please state your name out loud for me?
Roberto Flores Jr.
All right, if you could get a little louder into the phone or closer to the phone, you're a little quiet.
Flores Jr.
All right, thank you.
Flores Jr.
Thank you. Your attorney, Mr. Saldivar, has informed the court that you're agreeing to the terms of the agreement, which are for the department and belong to take temporary management conservatorship of the children, and for you and Ms. Guerra and the other father of the children to work services. Is that your understanding?
I'm aware of that.
Okay. Is that your agreement, and are you willing to work those services?
Of course, sir.
Okay. Are you entering into this agreement voluntarily?
Yes.
And did anybody force you to agree to it?
Of course not.
Okay. And were you made any promises or any kind of inducements to get you to agree to it?
No, sir. Of course not.
You're asking the court to approve the agreement?
Yeah, if that's what needs to be done, yes.
Okay. Anything else from the department?
That'll be it, sir.
I was asking the department, but thank you, Mr. Flores. I'm going to go ahead and mute you now. Anything else, Ms. Thompson?
No, Your Honor.
Does anybody else have anything before I hear from the ad litem?
No, Your Honor.
Ms. Harris?
The kids are doing great, Your Honor. The placement had indicated to us recently that she did not think she was going to be able to keep the kids because she has her own kids and lives in a small place. But as of today, we've been able to work out an arrangement where the grandmother is going to be in the home helping with the children. It's not extremely long term, but it will get us by for right now, and we can work on the future. So I'm just glad that the kids are going to get to stay together and stay in their old school.
All right. Thank you, Ms. Harris. We don't have a CASA on this case yet, do we? No, we do
Not
not.
a volunteer. CASA's been assigned, Your Honor, but not a particular volunteer.
Okay. Mr. Flores, if you could hit *6 and unmute for me one more time. I have a couple more questions for you. Sir, do you currently have the ability to afford an attorney in this case?
No, sir. I'm not even working. I mean, I just barely started. I'm barely going to start a job tomorrow, though. That's the good news.
Okay, but you don't have any money saved up. You don't have anything you could sell that would help you pay for an attorney?
I'm literally, no, sir. I'm literally broke.
Okay. I'm going to maintain indigency status for all three parents in this case at this time. We'll review it again at the status hearing. Court finds that there is sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the children caused by an act or failure to act of the person entitled to possession, and for the children to remain in the home is contrary to the welfare of the children. The urgent need for protection required the immediate removal of the children, and reasonable efforts consistent with the circumstances and providing for the safety of the children were made to eliminate or prevent their removal, and reasonable efforts have been made to enable the children to return home. But there's a substantial risk of a continuing danger if the children are returned home. Court will refer to the affidavit that the parties stipulated to, which contains information regarding the reasonable efforts that were made to return the children home and to avoid a removal in this case.
Okay.
Which Ms. Castaneda has testified to remains true and correct.
Your Honor, when I get a chance, can I ask a question?
In just a moment, ma'am. If you could just stay on mute for me right now so I can make my ruling, okay?
Okay.
And in the affidavit, there is a section entitled Reasonable Efforts.
Okay.
And you can stay on mute. I'm just reading things into the record, Mr. Flores. I'm not specifically talking to you, but thank you. And in that paragraph, it states the efforts that were made to avoid the need for removal, which was by engaging Ms. Guerra and Mr. Flores in services, referring them to a drug assessment, which Ms. Guerra did not attend, counseling that she did not start, and then domestic violence classes for the San Antonio Fatherhood Campaign, but she didn't register. There are some other things listed here that did not occur. Mr. Flores also was sent to some services that he did not participate in. And there was a power of attorney granted to Ms. Yesenia Flores, but unfortunately there was an incident in that home which created an issue, which also led to this removal. So those are the specific reasonable efforts made in this case. And despite that, we still had the issues leading to this removal. So the court will find that it's in the best interest of the children for the Department of Family Protective Services / belong, to be named temporary managing conservator, and for the parents to both be named temporary possessory conservators. The court makes no orders towards Vincent Bowles in this case, or his conservatorship. We will take that up again at the status hearing later. Court will also find that it's in the best interest of the child to remain in the current, or the children to remain in the current placement. That placement is safe and appropriate, meeting their needs and their best interest to continue. The court will order that the parties participate in a family group conference to develop family plans of service that are narrowly tailored to address the concerns that brought the children into care. I will defer child support and medical support at this time. We'll maintain the indigency finding for each parent and set a status hearing for, again, December 17th, 2024 at 10:30 a.m. I have to admonish the parents that the state of Texas gives parents in PPS cases 12 months to demonstrate that you can provide a safe, stable, violence and drug-free home for your child. If you are not able to do so within that 12-month period, your rights to your children are subject to restriction, as they are now, or termination. That'll be the order of the court. Ms. Guerra, you said you wanted to say something. I want to make sure you understand we're in open court and everything you say is on a record. Do you have a question that's legal in nature, or are you offering me information? You're muted.
Okay, so Vincent, I don't want him knowing nothing about the case.
Well, ma'am, he has to know about the case because he's the father. He has the legal right.
Okay.
So he's going to be involved. You just need to talk to your attorney and find out what kind of concerns you have and communicate those to Ms. Acevedo, okay?
Okay. Even though he hasn't been in Alberto's life.
That's correct.
For years.
That's correct.
Okay.
He still has rights.
Your Honor, based on that remark, can I ask Ms. Guerra under oath if she knows where he is?
Yes, you can.
Vincent Vos?
Yes, ma'am.
I don't know exactly where he is, but I know they have a piece of land somewhere out in the country. I can try and find out.
If you can find that out and you can give that information to Ms. Acevedo, she can get it to Ms. Pearsall.
Okay.
Okay. Did you have anything else, Ms.?
No.
Guerra?
That was it. Thank you.
All right. You're welcome. Ms. Guerra and Mr. Flores, I want to tell you something. And I kind of mentioned this a little bit earlier. There's two ways these cases can go. And it's usually one of the two ways that they do go. It's very rarely that they go another direction. Parents get involved real quick and parents do the things that they're being ordered to do. And they accept the fact that there are things about their life that they need to change. There are things about themselves that they need to change. And they work on those things. They get started early and they're successful in getting a reunification with their children. And then there are parents who fight this system every bit of the way. I don't think you don't have to agree with everything everybody says. You don't even have to agree with my decisions. And you don't have to agree with what another attorney says about you or your children. But if I make an order in this case, you have to follow it. Because if you don't follow it, that's when you run into trouble. I think we lost Ms. Guerra. But anyways, I wanted to put that on the record. Okay. Anything else that I failed to address? No? Okay. Well, thank you all for your service, your time and your service. That'll be the order of the court. Ms. Thompson, if you could hang on just for a moment. Everybody else is excused. Have a good afternoon.
Thank you, Your Honor.